Hey, Kevin.
Hello, Rebecca.
Guess what we're doing right now?
We're doing a readathon.
So, Kevin, what we're going to do in this readathon may seem like a little bit of a slog at first, but as you know, and as many people may know, there was an explosive moment in court today at this motions hearing for Karen Read.
Oh, you're going to make me wait to hear it? Oh!
Yeah, but I'll play a little clip of it right now to tease you.
So, the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
Oh man, that is so spicy. I can't wait to talk about that. But go ahead, let's build our way up. Start where we started and how did we eventually get to that outburst?
There is so much to talk about. A ton of motions were filed between our last readathon and this readathon, and then also responses to those motions. But today there was a hearing on many of these motions, so I can just talk about the hearing, and it was a wild one.
Okay.
Are you ready?
I'm ready.
First thing I will mention is that the one motion that was not covered in today's hearing that I was really hoping to hear about was the defense filed a motion to exclude the prosecution's dog bite expert. And that motion included a really, really pointed and sharp and, shall I say, acerbic affidavit from Dr. Marie Russell, their dog bite expert, who we saw in this 2-day hearing be questioned by the prosecution. Basically, she just says over and over and over again, this dude's not a doctor. He has no expertise. Not a doctor, not a doctor, not a doctor. And it basically says he says things in his report that she's never even heard of as a doctor. So that's what that's about. But it was not covered today. I'm going to put a link to it in the notes for this so that folks can read it themselves.
Okay.
Today's hearing was a motions hearing. And a couple of things are relatively quick. The first thing that came up today was that the Commonwealth requested records, uncut tape, etc., communications from Boston 25, where Karen Read did that interview last week. And basically, Boston 25 has since released the raw tape online, so that's available. And they've basically told the prosecution, no problem, we'll give them to you.
Yeah.
So judge was like, great, so that's all set, okay?
Yeah, sure.
Second one. The defense filed a motion to compel production of a forensically sound copy of the videos from the Canton PD. These are the videos of the Sally Port. These are the videos of all the stuff at the Canton PD once Karen Read's SUV was brought there. A reminder, they received 3 snippets of video. One before trial. That was the video of the Sally Port with 42 minutes missing, which would have been when Karen Read's SUV actually arrived. The second one they received during trial, that was the inverted video that misrepresented the position of Karen Read's car in the Sally Port. And the third one they received just in October, and that was the video of Higgins pacing around talking on his phone as he was leaving the Canton police station. Make sense?
Yeah. I'm up to speed.
So Jackson basically said, we filed this motion because we have no choice. We met with Brennan after the last hearing, as you told us to do. He basically represented that they were just going to get the video from someone's iCloud. And, you know, we thought it was all good. And then, you know, our Attorney Little, asked for the metadata and log files that come with this video. So, for instance, you know what metadata is, right? That's the data that's inside a thing that you can tell when it was made, if it was edited, and so forth.
Yeah.
So basically, Brennan said, if you want that, you need to file a motion. And that's what this motion is.
Oh, okay. So
essentially, the defense says they have been asking for this video uncut with metadata, et cetera, since January of 2022, which is just after the alleged crime was committed, right?
Sure. Okay.
Simple question. Brennan gets up after Jackson argues his motion and says, this is an effort by the defense to cry some sort of conspiracy again. You know, he retells the whole story from his point of view and says the retired detective at the Canton police station who says he has the video, he doesn't know if he has the whole thing. It's just, quote, whatever he decided to copy onto his machine. So he said that the defense has now changed their request. It's unfair. And he doesn't even know if metadata will be there. It's just a click and drag process. He seems very unprepared to argue this. And so there was no decision on that one. So that's still hanging out there.
Okay.
So second, one of Karen Read's other attorneys, David Yannetti, argued another motion they'd filed, which was to add Mark Betterow, another attorney, to Karen Read's defense team. We talked about that motion last week. We talked about who Betterow was. He's also representing Turtle Boy. So when Yannetti argued this, basically Judge Cannoni said, all I need is a more detailed affidavit from you, and then I'll probably allow this motion. So that's where we think we're going to leave it. But then Brennan gets up, and he has something to say. I would never deny the defense the right to hire whomever she wants to hire. But then he goes on to say that there is a history and symbiotic relationship between Karen Read's side and Turtle Boy's side, okay?
Okay.
There's a relationship not just between Karen and Aidan Carney, but between Karen Read's lawyers and Aidan Carney's lawyers. And therefore, Betterow would be serving two masters. He said that there's an ongoing long-term implicit mutual assistance and defense in these two separate cases. He says, I'm not opposing the motion. I just think the court might want to look into this ex parte. And then he keeps pounding the table when he's talking about this. He's very angry. Now, keep in mind, Kevin, Aidan Carney was just feet away from him while he was talking about this.
I saw online there was like a staring contest. So
yeah, a little bit. I didn't see the staring contest, but I just was very aware of the fact that Aidan Carney was there, hearing himself talked about in this case. So there was no decision on that one. Judge Cannoni decided to leave it there. So the next one is the Commonwealth's motion to amend their request for recordings from Gretchen Voss. That's the Boston Magazine reporter who interviewed Karen Read a while back. I plan to use some of it at trial. May I make a copy of it? Allowed. No one has any objection to that.
Okay.
The next motion was that the defense asked for access to Karen Read's Lexus, John O'Keefe's Chevy Traverse, and the driveway at John O'Keefe's house to conduct independent testing and their own reconstruction. Because you might remember, at trial, the defense showed video of what appeared to be Karen Read's car bumping John O'Keefe's Traverse as she was backing out of his driveway before she went back to Fairview and picked up Jen McCabe and so forth.
Which could explain why the taillight is broken as opposed to a pedestrian accident.
Right, cracked, not broken. Because there is video photos that appear to show her taillight is cracked but not broken after that. And they showed this very dramatic video that showed the SUV being bumped. And in the Commonwealth's version of that video, you couldn't see that, but in their version, you could. But what's interesting to me about this was it turns out the O'Keefes responded in their own motion saying they wanted to cooperate. The defense could have access to all of those things. So it doesn't really appear to be much of an issue at this point.
Okay.
There was a motion filed by the defense to reconsider the court's reciprocal discovery order. Do you know what reciprocal discovery is?
It sounds like when both parties have to turn over to the other side any evidence that they... Yeah, I'm much more aware of it for how the prosecution needs to disclose exculpatory evidence, but I guess this also means that the state could use it when preparing its prosecution if it knows, for example, who the defense is going to bring as experts or what they might testify to. Right.
So there's that. But this reciprocal discovery specifically spoke to impeachment evidence of witnesses. Because as you might remember, there was a federal grand jury before this case. There were interviews done, plenty of police reports, and there's certain information that the witnesses gave at trial 1 for Karen Read that was very inconsistent with some of that information in prior grand jury testimony and to the police. David Yannetti argued this one again. He said, cross-examination relies on the ability to surprise an accusing witness with evidence of their contradictory testimony, and they were deprived of that opportunity because of this order. And he mentions in particular Jennifer McCabe's lack of disclosure for her spending an hour of her life at Officer Lank's house. Officer Lank was one of the first arriving officers at 34 Fairview. Apparently, Jennifer McCabe has a relationship with him, and she went to his house at one point, which the defense only found out from the federal reports because they had Jennifer McCabe's geolocation data. And then they had to disclose that to the prosecution, and they said that Miss McCabe seemed very well prepared when answering this question at trial, implying that the Commonwealth had used that reciprocal discovery to coach witnesses. That was one of 2 examples they gave. The other example they gave had to do with the kids that testified, John O'Keefe's niece and nephew, who he was the guardian of. The nephew apparently told the police or somebody before trial that Karen Read and he had had a conflict, that she was mean to him at a dinner where they were eating steak tips. Now, the defense actually has video of this whole steak tip situation.
They have video of the steak tips?
Yes, Karen Read has video of her with the kids at this dinner.
Well done.
Completely disproving.
Well done.
Not well done. You know why?
Because it was medium rare?
Because at trial, what the kids said was it wasn't steak tips, it was a takeout dinner.
They got the steak tips detail wrong. So what, mistrial? What?
No,
straight to
basically,
jail? What?
The kid changed his testimony.
Oh, okay.
Okay. And they believe that was because the prosecution had this video and they were able to coach this kid. So what do you think of that? I mean, isn't it pretty common at criminal trials for the defense to be able to show up with stuff to surprise prosecution witnesses?
Yeah, I mean, unless they're, inventing evidence out of whole cloth. Yeah, I mean, it's an adversarial relationship, but I guess it's allowed. So otherwise, this wouldn't be something they're asking for, and it wouldn't be something they'd be able to have access to. So
right.
I guess we'll just see how it plays out.
Right. So one of the things that was also in this motion is that they pointed out that Michael Proctor had texted Adam Lally, the prosecutor in trial 1, after the end of the trial.
Uh-huh.
And in those text messages, he told Lally that he'd been watching the trial. He just didn't watch Jackson.
The closing arguments,
because Alan Jackson is a, quote, asshole. What that disclosure spurred is that the prosecution has actually filed a motion for sanctions against the defense because all of Proctor's texts are supposed to be under seal. That was not addressed today, but it was interesting that fact was there. So I'm going to go through the next one quickly, but there are a couple of big things that come from it. Attorney Little for the defense, that's Alan Jackson's partner, she filed a motion to compel discovery from the Commonwealth. It includes all sorts of things related to the Sallyport videos, including a disclosure of the chain of custody and logs for how the prosecution actually got those 3 clips to begin with. I would think that would be something that they would know or have, don't you?
One would assume.
What Brennan said was, we're not going to invent something just so you can have it. There's no logs. There's no chain of custody. And what this brings up for me was, how would these things even be allowed in if there's no chain of custody of them? But I guess that doesn't matter in this trial.
That's spicy.
It is. All right. So then she mentions the ongoing, I'll repeat that, ongoing federal investigation.
Mm-hmm.
And that the Commonwealth can't skirt their obligations simply because they don't want people mentioned in those logs to be asked about them at trial, which is her kind of accusation. That's why they don't want to give up the chain of custody stuff.
Okay. Okay, so
all right?
It all ties into the discovery. Okay.
So the next categories of stuff, and I'll just summarize it, are all about the Sandra Birchmore case.
Mm-hmm.
The defense wants everything related to the Norfolk County District Attorney and Police's clearance of Matthew Farwell in the murder of Sandra Birchmore.
I am guessing that they are going to try to imply that these Canton police officers, who were part of both the Sandra Birchmore case and the Karen Read case, because they either messed up or they did something sketchy with looking at the crime scene of Sandra Birchmore and, pushing it towards that it's a suicide and it wasn't a homicide, that they can use that information to impeach their credibility when they appear or reappear at the Karen Read trial.
And Little pointed out 10 people that these two cases have in common. 10, including law enforcement officers, including Guarino, including the Norfolk County DA himself, Michael Morrissey. Basically, interviews were conducted by Fanning. He was also a character in the Karen Read case, a trooper named Prince. All they want is unredacted copies of all that. Same with public records, emails, and comms related to this case. They want basically all of this stuff. Now, Brennan gets up and he said something really interesting. He said he's never seen a report where Nicholas Guarino says that he couldn't find any text messages that made Matthew Farwell look guilty in the Sandra Birchmore case. He's never read it, he's never seen it, and that Guarino never said there's nothing to see here. Interestingly enough, it took Twitter about 2 minutes to post that memo where Guarino says he found nothing of interest.
Yeah, that was a document filed by someone else, not by Guarino, but somebody saying that Guarino didn't have anything.
So basically, she says this speaks to Guarino's bias, competency, etc.
Because we keep going back and forth about what time House Long to Die in Snow was typed,
Yes.
and he has an opinion on that. If he's saying, in this other case that he couldn't find any text messages, and then someone else was able to find 30,000 of him, it isn't like he missed one. He missed an important one, and then that's one of the reasons why someone who was a murderer almost got away with it. The size of it is so big. It just looks so bad that even if it was like, this was like one little click thing and I would have found them all, it just really just looks bad for his not just his credibility, but for his competency. So that, I think, among all the ones here, like, with this and that, I mean, we keep nibbling around the edges here about all these little different discoveries and disclosures and stuff, but that's a big one.
Yeah, there was something really interesting also that happened in Little's rebuttal, talking about the Commonwealth's objection to these motions. Mm-hmm. They asked for these internal affairs documents around Michael Proctor because his hearings deal with accusations of misconduct in the Karen Read case. Mm-hmm. And Brennan files this long objection. And Little says, the Commonwealth's objection to this motion is interesting because their request is copied verbatim from Brennan's objection to bringing in the ARCA experts. So basically, he can dish it, but he can't take it. They literally copied and pasted the words of what they were looking for from his motion. And then he basically claimed that their motion is insane, out of bounds, blah, blah, blah. But it's just his motion with new words, which I thought was wild that they would do that. This is the big one, all right?
Yes.
There was an incredibly dramatic moment in this hearing today, which I know you know a little bit about.
I can't believe we're getting to this now. This is the lead. This is the lead on every news website. Grave concerns.
What did you see that happened in court today that you think I should be talking about this whole time?
Well, the reason that the hearing was stopped.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
And at this moment, it hasn't been disclosed, but there are a lot of inferences based on what was being discussed at the time before the recess.
I know exactly what the issue is.
Okay.
I figured it out. I mean, it's not difficult to figure out when you watch this thing. So Hank Brennan is arguing to exclude the ARCA experts. He says he doesn't care what their opinions are, which probably isn't true. He doesn't care about their opinions about the case. What he cares about is that Jackson seems to have misrepresented the defense's relationship with the ARCA witnesses at trial number 1. All right? He said that, in his vast experience with cases, he doesn't believe that the feds are always forthcoming with all of their stuff. So he reached out.
Yeah. Right. Okay. Yeah.
Remember, he defended Whitey Bulger.
Yeah.
So he reached out to the feds, and the feds emailed him a bunch of stuff. And what that stuff included was emails between the defense and ARCA, especially between Daniel Wolf, who was the
feds had emails between Karen Read's defense and ARCA.
That's what he says.
Okay.
And he says those emails included some very incriminating things that he didn't say this outright, but clearly was pointing to Alan Jackson having perjured himself in trial 1. I don't know if a lawyer can perjure himself, but lied in trial 1.
Yeah.
Okay. He asked Daniel Wolf on the stand, have we ever spoken before? Have we ever talked before? Did I pay you? Blah, blah, blah. And he's just like, nope. Okay.
Right. And one of the reasons they need to do that is because the judge would not allow ARCA to disclose that they were hired by the feds. So they had to somehow explain in an opaque way why they were here and to establish their bona fides. And again, as we know from hearing from what the jurors said afterwards about ARCA, that if they had known a little bit more about how they got there, they would have given more weight to their testimony.
Interestingly, Brennan says there was an email between the defense and Daniel Wolf in March before trial 1. And basically, all that email is, I'll just say it, was an engagement letter to testify. Can you please just send me the engagement letter? I'll sign it. That's the only email, by the way, for which he provides a date, March before the trial, March of 2024. Then he talks about the content of a bunch of other emails between the defense and ARCA, which are clearly witness prep emails. ARCA kind of gave an outline of what they could testify to. And then in the margins, there were notes between Alan Jackson and the ARCA guy saying, can you really say this? And the guy saying, yes, things like that, right? Remember, he said this came from the feds. He also said there was a bill in this information, in this email set, for $23,000 that ARCA billed the defense. So this would mean that Alan Jackson lied because he asked Daniel Wolf all those questions and that Daniel Wolf also perjured himself, right?
Right.
At this point, Judge Bev Canoni abruptly calls the recess. She looks very pissed. Basically, it's because he's representing the defense, was in contact with ARCA prior to their testimony in voir dire, etc. Okay? She came back and said,
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
Now, Brennan says, I need to actually give you a brief chronology here. And she says, go ahead. That email, that stuff that he just described, did not come from the feds. It came from the defense in a disclosure.
Okay. So those emails and the bill,
yes,
was disclosed by the defense.
Yes.
Okay.
And he says none of those things had dates on them, so he can't say what the dates are. It is extremely clear because it also included in his thing was that the FBI has now ended their contract with ARCA. That was in this disclosure of emails and them saying, like, basically, if you want to engage with ARCA, like, you got to do it yourself and we're not going to give you any of those materials. You got to get it from them now.
Yeah.
It is extremely clear that all of the things he cited as being, like, awful, that's this lying about the relationship, is all prep for trial 2.
Okay, so you think that this bill and these discussions occurred after the first trial and this is preparation for trial 2.
Yes, it's actually pretty clear because why would the defense send them to them if it wasn't that? That's reciprocal discovery, right?
Yeah. Including bill. Yeah, I mean, I suppose that like when you hire any sort of technical expert, they expect to get paid. That's not new. And so that probably is something that would be disclosed. But then why such a visceral reaction from the judge if you think it's as simple as what you're saying? Because
when he was talking, Brennan said all this stuff was undated, except for that one March thing he mentioned, which was literally just a request for a letter of engagement to testify.
And just to be clear, what you're saying here when he says, but I have to go over the chronology, did this occur before the recess or after the recess? So after she comes in, guns blazing, telegraphing that she's going to sanction the defense attorneys for something. Then Brennan says, I don't have the dates for this.
No, he said he didn't have the dates at the beginning, before the break, because what he was implying is that there's a relationship there, but he doesn't specify when he got the stuff or whether there were dates on it, okay?
All right.
But he clarifies that after the break, okay? He says, the defense provided all the emails I read on February 15th, 2025.
That's Saturday.
Yeah. So this is clearly prep for trial 2. Clearly.
Yeah, because I would imagine that if they got, if the prosecution got something that they thought was a real bombshell, they have been arguing this in court for several weeks now, and I don't feel like they would have had this in their back pocket all that time without revealing it. So it would have to be something that just came to their attention. And so they found something in discovery that they found
a bill for $23,000 and emails going back and forth.
An undated invoice for $23,000.
That's what they're claiming. He's claiming this stuff.
Who's they?
He didn't mention a date. That's what Brennan is claiming. He didn't mention a date for anything except for that one email, which was a request for a letter of engagement for me to come testify at your trial. That did happen before trial 1, okay?
Right.
Everything else he cited, they received on February 15th. Now, Alan Jackson was asked outside of court by Christina Rex, the television reporter, if he paid the ARCA experts to testify at trial 1. Of course not, he says.
Yeah.
So of course not. This is all very clearly prep for trial 2 that Brennan, dare I say, is misrepresenting as prep for trial 1 in order to impeach these witnesses.
It's one way or the other. It seems like somebody here is way out on the plank about what they're representing about this bill. So either Jackson has paid, or maybe it was, payment for services rendered after the fact. I don't know. But I mean, that's just, one of the ways of one could look at it. If they didn't pay for prep for trial 1 or for services rendered for trial 1, either before testimony or after, because I imagine that like the expert witnesses, they may take some money up front, but I'm sure that they don't get paid in full until after they testify, because something could happen in a case like where it's dismissed or whatever before they even get to them, right?
Right.
So you're not going to pay somebody $12,000 for not for not being able to render those services. So my point being, either this is really bad professionally for Jackson, or this is really bad, I don't know, professionally, but it'd certainly be bad for Brennan, the special prosecutor. So the stakes all of a sudden on this one point have become super high.
Yes. It is, to me, extremely clear that this is prep for trial 2.
Then why didn't Jackson explain that in chambers to Cannoni before she comes in all pissed?
All right, there was no chambers. She just called a recess and she left the courtroom. There was no in-camera discussion or anything like that.
Well, then how did the Commonwealth just inform me?
She meant in court. She meant in court.
Okay.
It was very clear what she meant. She meant in court, the Commonwealth just informed me of X. That's what it appeared like to me.
Okay.
It did not appear to me as if there was an in-camera conversation that we weren't privy to. She was just pissed.
I mean, I know that Judge Cannoni has not done everything she's not like a white paper in how to, handle evidence and motions in a murder trial. But it just seems like somebody's jumping the gun.
Yes.
To say oh, this is horrible. The implication could be I'm going to have sanctions filed against you without even hearing from him. And that's making a big assumption about, and now when I'm doing this, I said, oh, well, this seems very obvious that in this recess, heard from both sides, and Jackson couldn't come up with a simple or a satisfying answer for what this bill is, and then they have to go back into open court so that they can.
I know
get
that's
this on
not
the
what
record.
happened, because you know what she didn't say?
What?
She didn't say, "Come speak to me in chambers." She stormed out of the courtroom, stormed out, and then stormed back in. It was pretty clear that they had not talked in chambers to me, because she didn't request them them to come to her chambers.
So in the interview with Jackson after the hearing, what else was he asked? What else did he say?
That was
about
it.
this?
That was all I saw so far. I'm sure there's more, but I haven't seen it yet, because literally this just happened as we're taping this.
Yeah. Okay.
So the thing that really strikes me, Kevin, is that there's clearly some trial prep for trial 2 going on between the defense and the ARCA witnesses, which is totally normal.
Right.
This bill for $23,000, it probably includes that time, right? So it's that plus, what they're going to do, travel, all that stuff.
Yeah. I will say one thing, too, that we know that the feds did pay ARCA for some of their work.
Correct.
And that, the feds indicated that their contract ran out with ARCA, and they're sort of implying that, okay, Karen Read's defense picked up the rest of that bill. But I don't see why they would double dip, right?
Yes.
That they would ARCA would get paid for the same work that, the feds have already paid for, or, whatever. But please continue.
Now, Anti-Karen Read Online is saying, oh, the defense paid for that glass cannon that guy built. No. It's very, very clear. I'm telling you, Kevin, if you watch this, it is so clear what's going on, because Brennan, when she stormed back into the courtroom, immediately felt as if he had to clear that up. She seemed really, really angry when he said, I got all these emails, and she asked him in court, now you got these emails from the feds? And he said, yes. He was either lying or completely misspoke. That was what set her off and made her call the break. She was super angry. She thought the feds were basically revealing misconduct by Alan Jackson. Okay?
Okay.
Then she comes back in the courtroom and he immediately says, I need to give you a timeline on this. I actually got all this information from the defense. in a disclosure this past Saturday.
Yeah, I saw that now. I saw that clip, and now I understand the context of why that was important.
Right. I don't want anyone to think that this is a matter up for interpretation. Hank Brennan absolutely, I rewound it, I watched it again, absolutely misrepresented the origin and timeline of this email conversation and this document stuff. He absolutely misrepresented it to make Jackson look like he lied in the first trial and to make Arca look like they were perjuring themselves. And then when she came back, he told the truth. If you see, fair listeners, any claims out there that Alan Jackson lied and that Hank Brennan discovered something, then you haven't seen part 2 of this hearing after the break. You have to watch it. So, you can look at the Young Jerks YouTube channel. They have part 1 and part 2. Just watch part 2 if you want to see like what happens when he comes back. It's only a couple minutes long. Then they spent the rest of the time just scheduling when the next hearing is going to be. And good news, Kevin, it's going to be next week.
Oh, yes. Right. Yeah. Well, certainly when like the judge came back from the recess, it sounded like that she wanted to have a hearing next week and it was going to be on this issue, on the issue of the bill.
Correct.
So I guess, that I'm just surprised that like this hasn't been clear. But let's just do one hypothetical thing here. Suppose you're 100% wrong and this, there was something shady or whatever. They were obfuscating what the bill was and what it was for. So what are the consequences for the defense? The consequences probably are that the judge would bar the testimony of the ARCA guys.
Correct.
And that there would probably be some, recommendation of censure or disbarment or something along the lines, a professional conduct sanction against Alan Jackson. But it doesn't send Karen Read to jail.
No. What's interesting to me about this whole hearing is that one of Karen Read's lawyers would get up and lay out a very straightforward and simple case for why they wanted what they wanted. Very clear to me. Okay? Mm-hmm. This is why we want it. This is why we asked for it. This is the problem. They haven't given it to us. That's all we're asking for. Literally every single thing was that.
Mm-hmm.
Hank Brennan would get up and respond to all these things in, I'm just going to say it, like nonsensical circles. He would tell a version of the story that we've sort of already heard before, but it would include new details. And it was basically everything was like, they're just crying conspiracy. At one point, he says, they're just trying to entertain the crowd here. He literally said that. They're just trying to entertain people with this. Mm-hmm. And he literally offers nothing of substance back. He doesn't say, Your Honor, there is no metadata. He says, Your Honor, I don't know if there's metadata. I don't know. I haven't seen it. I don't know. That's all he says. He basically uses the, plausible denial argument instead of just saying concretely, we don't want to give it to them for this reason. You know what I mean? He just won't respond in a clear way. He is a game player. And I think that Cannoni, because she is so trusting, I'll just say, of the prosecution side, has fallen into that trap a couple of times, and this is an excellent example of that. To be fair, though, he did clearly misrepresent where this information came from.
Right, either intentionally or unintentionally.
All right, so we're going to be following that next hearing, which is going to cover the other motions that they didn't get to today. Mm-hmm. As soon as it happens, we'll of course tape and talk about it, and then we'll talk about the fallout from this. Kevin, thank you so much for joining me today.
You're welcome.
Partners in Crime Media.